Hi guys, it's Kathy. I hope you're doing well. We made it to Friday. Yes. I love Fridays because it's payday every other week. Friday. Today. First paycheck from my new job. That's awesome. That's great. So you guys had a good day yesterday? I didn't read every single live chat replay message, but I read most of them. See? Like, I told you guys 100 times. This is court vibes. Chat is more court vibes than me or anything that I play as a video. We don't even watch the videos half the time. We watch chat. And sometimes we hear some of the video-ish, maybe. But we watch chat. Chat is court vibes. You guys are court vibes. You guys carried the whole show yesterday on your shoulders like it was nothing. You don't need me. I did, except I was sleeping. But if I was awake, Maria, I would have missed you so much. But then I was working, and I had to just keep getting extra lemons for people, so I didn't have time. I'm so glad I'm live again today, though. I don't like premieres. I mean, they're okay. They're good when you know, like, it was either a premiere or nothing yesterday. So, at least we had a premiere. And I'm not mad at you guys exactly. I'm just a little disappointed. Just a tiny bit disappointed. I gave you a video where a body part was on his head multiple times, and those jokes wrote themselves, and nobody ran with it. Nope. I don't think you were listening to the video at all, actually. I don't know. I just don't think so. I probably would have said a few inappropriate comments, and nobody did in my stead. Nobody. Gina. Hi, Gina. Okay. Today's sort of a good news, bad news for everybody, but for different reasons. Okay? Yes, Martha, that's true. Good news for some people is I'm starting out with crazy clips, people crying and you know, talking over the judge and everything. That's what I'm starting with. Plus they're in a cage. Plus it's in California. Not that cage in California, a different cage in California. And I'm so excited to show you because we've seen this courtroom a couple times, and the audio is so terrible that you know, it's just the people in there are great, but I can't play this court because the audio is so bad. Well, they just did a big 180. They flipped the video around. Now you can't hear everybody perfectly, but you can hear so much better now. So I'm excited to show you that. And then after that, we're going to this judge in Connecticut that I haven't showed yet for civil matters. So it's very, very lawyerly and very, very courty. And nobody's screaming and crying and yelling and melting down. The judge is just very direct and stern. I don't know if that's the right word. And I just enjoyed the heck out of watching him. I was waiting for someone to get in trouble the whole time. So we're gonna watch that afterwards. And this is not something we normally play on this show because it's, you know, it's just lawyers. It's just a bunch of lawyers and a judge talking about law. So half of you who want to see the crazy court clips, you get it at the beginning. The other half who want to see court and law, you get it at the end. But, some of you, like 3 of you, might want both. And this whole video is for you 3. Alright, let's see. I feel like I forgot to do something. And I'm missing something, but that's okay. I know I shouldn't, Maria, but if I didn't leave you unattended, I would have left you to your own devices, and that's worse. I have to tell you what to watch. I can't just let you find your own videos. That's crazy. You're going to start sending super chats to yourself if I do that. Speaking of, don't let me forget to thank Zach later, because he sent me a super chat yesterday during the premiere and I wasn't here to say thank you. So I do have to say thank you to him. And I think yesterday, Josh, I think it was yesterday. It could have been 2 days ago and I missed it. Josh resubscribed on Twitch. So in case you didn't know, if you have an Amazon Prime membership, you're allowed to subscribe to one Twitch channel a month with that membership. And then you don't see any ads. So if you're seeing ads during this live stream and you have Amazon Prime, go watch it on Twitch instead. It's streaming on Twitch. And if you use your Amazon Prime membership to subscribe to my channel, then you don't have to pay, and you don't have to watch ads. Alright, here we go. I feel like I'm forgetting something important, but it'll hit me eventually.
Can we do protective order violations on the record? This one does not need to be on the record. Number 197, Wesley Wayne Parrish. Can you step forward to the microphone, sir? The reason we need that, we're being live streamed and nobody can hear you unless you're talking to the microphone. Okay, sir? What's that?
It's a no offer case.
Okay. Is your name Wesley Wayne Parrish, sir?
Yes, sir.
Is your date of birth October 16, 1984?
Yes, sir.
All right, I'm going to go over the charges with you so you understand what you're being charged with, sir. I'm not saying it's true, I'm just saying this is what you're being charged with, okay?
Okay.
It is alleged on August 14, 2025, you violated a court protective order. Public defender is appointed.
Thank you, Your Honor. We accept the appointment, acknowledge receipt of the complaint, waive formal reading and advisement, and plead not guilty. 4.9 state federal constitutional rights for several motions, make an informal request for discovery, request statutory dates, and I'd like to be heard as to Mr. Parrish's release.
Oh, she didn't do her appearance? What is your appearance?
Oh, apologies. Isabel Guerrero, Deputy Public Defender.
Thank you, Ms. Guerrero. For the people?
Brianna Shelley for the people.
Thank you. Ms. Guerrero, you wanted to be heard on the issue of bail?
Yes, Your Honor. Mr. Parrish does not have any ability to pay any amount of monetary bail. He does. He's been unemployed for about 4 to 5 years, homeless for about the same amount of time. He's been living off of food stamps and GR. He has indicated to me, though, that he does have friends locally close to the courthouse he would be assigned to in Garden Grove that he would be able to stay with while his case is pending. He's provided us a phone number for us to reach him so we can ensure he would be coming to court. We also talked about the particulars of the protective order, what he is allowed to do, what he is not allowed to do, and he has indicated that he will be complying with the protective order going forward. And I would just point out that this alleged protective order violation doesn't involve any kind of violence or even direct contact with the alleged victim. So I do believe that Mr. Parrish could be released on his own recognizance, will come back to court, and does not pose any danger to the community. With that, I will submit.
All right. Do you have any objection to me looking at his rap sheet before I consider your request?
No, Your Honor.
All right, people, what's your position on release?
The people would be requesting scheduled bail, Your Honor. There's an extensive history involving this victim
as well as 422's multiple protective order violations and a history of violence involving his parents. There are currently 5 different no-contact protective orders in place.
Defense, is that true?
I'm not sure about how many protective orders there are, but I did see that there were other 166 charges in his record.
Fair enough. I'm looking through Mr. Parrish's rap sheet. It is 40 pages. I see prison commitments. I see domestic violence convictions. I see firearms. I see violations of probation. His defense is aware, before we get to the ability to post bail, a determination first needs to be made that there is no danger to the public, and with multiple protective orders in place, and with the rap sheet that I'm looking at, which again is 40 pages, the court determines, based on the evidence presented, the criminal history of the defendant and the nature of the charged offense, that public or victim safety and or the defendant's appearance in court cannot reasonably be assured without the setting of bail, and that by clear and convincing.
Right? Isn't the audio so much better? The last time we saw this cage in California, Monica, Kelly, thank you for the bits. Oh, Martha, they're different. Thank you for the bits. 100 and 100. Wow. The last time we saw this cage, I don't know if you remember, there was a mattress in it, standing up. So the guy was in there alone. No one else was allowed in there with him. And they had a mattress in it standing up so that, I don't know. Like, I guess he couldn't bang into it, or I don't know. But, so the last time we saw this, I don't know if you can see my mouse. You can't. Over to the left, sort of where my camera is, we had the lawyers standing talking, and you could barely hear them. Or they were standing where she was standing right there, and the only thing you could really hear was the person in the cage, because there's a microphone there, freaking out, and the judge replying, and you didn't hear anything else, and you sort of had to guess what the lawyer was actually saying. It's not perfect audio, but oh my gosh, it's so much better. It's so much better that we can play this now. But I have to play this one very carefully because, yeah, it is very messy. And a lot of people can't handle this. this chaos. This is where they're doing court, guys. But this is Sacramento, California, I believe, which is awesome that we get California. It's awesome. I love it. I just wish we'd get New York. Oh, I wish we'd get New York. But let's keep going with California for like 6 or 7 of them, and then we'll switch to the lawyers.
Convincing evidence, no non-financial or less restrictive conditions of pretrial release will achieve this public safety goal. The court will set bail in the amount of $20,000.
Kelly, I saw that. Kelly was watching that clip in Russia where the guy was in the cage and he climbs out over the top. And and he's like, they're trying to catch him. It's an excellent clip. It's been circulated for a while. You guys probably saw it.
Pretrial September 2nd, W14. Jury trial September 8, W18. Those are both within time. There will be no time waiver. Defense, did I miss anything?
I don't believe so, Your Honor.
People?
No, Your Honor.
All right, that'll be the order of the court. Good luck to you, Mr. Parrish.
Thank you, Your Honor.
Okay.
Actually,
Every
Your
time.
Honor, should the defendant bail out, the people would be requesting as a term of release that he comply with the protective order already listed in the other cases.
Thank you for reminding me. Mr. Parrish, should you bail out, I'm going to set the following terms. You're to submit to search and seizure. That means anytime, day or night, with or without a warrant. If a peace officer asks if he can search you, your answer is yes. You're to possess no weapons or ammunition. Maintain contact with your attorney, but obey all laws. That means do not violate any felony or misdemeanor laws. Stay away from and have no communication with the protected party. Stay away from the location involved in this incident. Madam Prosecutor, what is that location? And give me the name of the protected party.
Yes, Your Honor. The protected party is a Ms. Kim Parrish. And the stay away order is 100 yards away from the home, job, or workplace and vehicle of that individual. And it appears that the address is one.
Ray is. What city?
That is.
Garden Grove?
Yes, Your Honor.
All right, sir, that may have been the place where you lived, but if you bail out, you don't live there anymore. And those conditions will be in effect until this case resolves, one way or the other. Okay, sir?
Thank you.
That'll be the order of the court. And thank you, Madam Prosecutor, for bringing that to my attention.
Thank you, Your Honor.
Ooh. All right, the court will next call number 24. This does not need to be on the record. That's Michael Mitchell Stevens Hilgerman. Are you here, Mr. Hilgerman?
Sure.
Could you step up and go to the microphone, please, sir?
Sure.
All right, the bench warrant will be recalled. This is case 25CM06666. Mr. Hilgerman, is your date of birth January 23, 1998?
Yes, sir.
All right, well, welcome to court. I'm going to go over the charges with you so you understand why you're here. It is alleged on June 30, 2025, you were in possession of controlled substance paraphernalia. I don't know if that's true or not, but that's what you are being charged with. Let me speak to the prosecutor, see if she has an offer for you. Okay, sir?
Brandon Shelley for the people, Your Honor. The people's offer would be credit for time served.
All right, sir, so you have a couple of options here. If you want to enter a not guilty plea and fight this case, I'd be happy to appoint the public defender and have you in a jury trial within 30 days of today. That's one potential option for you. Another potential option is if you want to plead guilty, the district attorney has offered you credit for time served, which means you'll be out tonight. The court will waive all the associated fines and fees, and you will not be on probation. So you get out tonight, the case is resolved. That's another way to handle the case. Do you know how you want to handle the case, sir?
Yeah, I'll take credit time, sir.
Okay. Before I accept your guilty plea, I have to advise you, if you're not a United States citizen, you're hereby advised that a conviction for the offense for which you have been charged will have the consequence of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. I also have to advise you that you don't have to plead guilty. If you wanted, I would appoint the public defender's office. They would represent you. Like I said, we could have you in jury trial within 30 days of today. At that jury trial, you'd have the right to testify, or you could remain silent. I would advise you that you have the right to confront and cross-examine all witnesses against you. You have the right to use the court's subpoena powers to subpoena witnesses or documents into court that you believe would be helpful. Understanding all of your trial rights, do you wish to waive them and give them up in order to plead guilty and take the offer?
Yes, sir.
How do you plead then, sir? Guilty or not guilty?
Guilty.
I'll accept your plea. I find a knowing, intelligent, voluntary waiver of rights. I will sentence you to 6 days in custody. You have credit for 6 days. This will be a terminal disposition. No fines, no fees, no probation. You'll be released tonight, sir. Good luck to you. Okay, sir?
All right, thank you.
All right. That will be the order of the court. Anything else for the people?
No, Your Honor, thank you.
All right. Yeah. 12242. It's alleged on November 1, 2024, you, in violation of the Santa Ana Municipal Code, stored personal property in a public parking lot, and count 2 is another misdemeanor for unlawfully camping. And last but not least, 24 CM 11025, it is alleged on October 10, 2024, in violation of the Santa Ana Municipal Code, you obstructed the public right-of-way again. Public defender is appointed on all cases.
Thank you, Your Honor. Isabella Guerrero, Deputy Public Defender. We accept appointment, acknowledge receipt of the complaints, waive formal reading and advisement, enter pleas of not guilty, deny any priors, enhancements, and allegations. Both my client's stated federal constitutional rights, reserve all motions, make an informal and continuing request for discovery. And I would like to be heard as to Ms. Grettenberg's release and set statutory dates in C-57.
Please.
So in regards to her ability to pay, she has no ability to pay. She has been unemployed for several years. She is currently surviving off of GR and food stamps. She's also on Medi-Cal. She's also indicated to me that she has also been unhoused for several years, primarily in the Santa Ana area. She does have strong ties to the area, to the Santa Ana area. She's lived in Orange County primarily since she was about 1 year old. She's also indicated to me that she does have, her mom lives in Irvine. She used to help take care of her mom, and she's indicated that her mom would be a good support person for her should she be released on her own recognizance. I do have the contact information for her mother so that we can get in contact with the client as well. We also had a long conversation, and she's indicated to me that she's going to go straight to Project Kinship, or try to go straight to Project Kinship upon release to help get connected to the resources she needs and to some emergency housing services. And then in regards to her ability to come back to court, she's also indicated to me that she is able to take the bus, or that her mom can drive her to and from court. And then in regards to danger to the community, all of the cases here are for possession or charges related to her unhoused status, and based on the rap sheet that I've been provided, I don't see any convictions for any violent offenses. So I do believe that Ms. Grettenberg should be released on her own recognizance because she doesn't have that ability to pay, because she doesn't pose any danger to the community, and because I do believe she will come back to court because she has support, and with that I would submit.
People?
Your Honor, in this case, the people would be asking for scheduled bail. It appears that the defendant has 2 cases currently in warrant status.
All right, yeah, I tend to agree with the defense in several points. One, I don't find that Ms. Grettenberg poses a public safety issue in any event, in any way, shape, or form. So that's not an issue. The court will make a finding that she is indigent, so if the court can be assured that she will appear in court, it would warrant an OR release. However, she is in warrant status on 4 cases, 24 CM 08551, 24 CM 08774, 25 CM 03972, and 25 CM 05148. With 4 active warrants, the court simply can't be assured she will come to court.
I will.
Based upon that, the court determines, based on the evidence presented, the criminal history of the defendant, the nature of the charged offenses, that the defendant's appearance in court cannot reasonably be assured without the setting of bail, and that by clear and convincing evidence, no non-financial or less restrictive conditions of pretrial release will achieve this goal, and the goal is assuring that she will appear in court. The court's going to set bail of $1,000 on every case. The court will also
I'll never get that.
set a pretrial August 26 and C-57. That'll be all cases. Preliminary hearing on the felony case, August 28 and C-57. Counsel, with regard to all of the misdemeanor cases, will set a pretrial August 26 and C-57. Would you grant the court general time waivers for all the misdemeanors?
Yes, Your Honor. I apologize, Your Honor, for interrupting. I would just ask for bail to be at a lower amount for the misdemeanor.
I do not have any money. I will go.
I won't do that because I'm
Can I
looking
go to a program?
Ma'am, excuse me, let me just finish. 24 CM 08551, there's a warrant that I just recalled for $2,500. I'm actually lowering the bail on these cases.
I have no money.
So respectfully, I'll deny.
I have nothing. I have no one
Ma'am,
that has money.
Ms. Walton, please. Bail's $1,000 on every misdemeanor case, general time waiver on every misdemeanor
Please give me
case.
a program.
Pretrial will be set on all the cases August 26th. Ma'am, if you want a program, ask your next attorney on August 26th. I'll be happy to set you up with that. That'll be
I want
the
a
order of the court.
program, please.
Anything else for the defense?
Nothing further, Your Honor.
For the
Can I
people?
talk to my attorney, please?
Sure. I'll tell her you want to speak with her, okay, ma'am? That'll be the order of the court. Thank you, bailiff.
And Your Honor, may I have one moment to speak with Mr. Peluso? Looks like DNA is on their way here.
Of course.
You gonna wanna talk to her as well on Zoom again or not?
No, that's all right. Thanks.
We're on our way, sir.
All right, calling number 40, Valentina Moye on Zoom.
Yes, on our way to her.
Oh, okay, fair enough. Let me know when you get there. No big deal.
Okay, thank you.
What do we have out here?
We have 42, 88 to 1, 49.
Well, sit down right here, hon.
Okay, thank you. Thank
This
you.
is your court. Go ahead and take a seat over there on the.
All right, Miss Moye, can you hear me? Miss Moye, can you hear me?
Yes, sir.
Is your date of birth September 27, 1991? Oops, deputy, looks like the screen froze. Miss Moye, can you hear me?
Yes, sir.
Is your date of birth, ma'am, September 27, 1991?
Yes, sir.
Let me go over the charges with you so you understand what you're being held on, okay?
Okay.
First is case 25CM06236, where it's alleged on July 9, 2025, you're in possession of controlled substance paraphernalia. That's one case. Your second case, which you're in warrant status, 25CM01930, that warrant will be recalled. It is alleged on February 7, 2025, you were in possession of a usable quantity of methamphetamine. That's charged as a misdemeanor. Your third case is a city attorney case, 25CM03810. That's in warrant status. That warrant will be recalled. It is alleged on March 26, 2025, in violation of the Santa Ana Municipal Code, you were unlawfully camping in the street.
Yes.
Those are your three cases against you. Do you understand what you're being charged with, ma'am?
Yes, sir.
Okay. Let me see. I'm more than happy to appoint the public defender to assist you, but before I do that, let me talk to the people, see if they have an offer for you.
Okay.
Yes, Your Honor, very much. Charlie, for the people's offer would be 90 days jail or the OTP program, paperwork to be done at the pretrial.
Will we typically continue the arraignment on these?
Oh, I see, at the continued arraignment, then, Your Honor.
Okay, yeah, well,
Still got a continuance form today.
okay, yeah, I'm hearing that they would go to the DA's office, fill out the paperwork tomorrow.
Tomorrow?
Yeah. Okay, Ms. Moye, am I saying your last name right?
Yes, sir.
Okay, you've been made a couple of offers. The first offer is from the district attorney, 90 days in jail. If you want to plead guilty to these cases, you'd be sentenced to 90 days in jail. Now, you'd serve 45 days on that, less the time that you've already served. It looks like you've already served 4 days. So if you were to take the offer, you would be released in 41 days. And at that time, there would be no fines or fees because the court would delete them for you. And you would not be on probation. So in 41 days, you'd get out. These cases would be behind you. That's alternative number one. Alternative number two is I can appoint the public defender. We can set jury trial dates. And within 30 days, you could be in jury trial. That is alternative number two. Alternative.
Jury trial for 30 days, can I be released today until jury trial?
No, I didn't say that. There is an alternative where you could be released today. It's called the Offender Treatment Program. If you agreed to enter into a treatment program, understanding it's a 6-month program, you'd be released tonight. You would be ordered to
Okay.
report to the
I will
district.
do that.
Wait, let me finish. You'd be ordered to report to the district attorney's office tomorrow to obtain more information on the program and to actually sign up for the program. They would actually swab you for DNA at that time, and the people will enter into a waiver of that fee, correct, people?
Yes, sir.
So that is an offer. You want
I
to
can
get,
release today, I can do that tomorrow.
okay, well, let's do that then. Do you agree to go to the district attorney's office tomorrow and fill out the paperwork and give a DNA sample?
Yes, sir, yes, sir.
Is that the option you want to choose?
Yeah, get released today and then do the DAA office tomorrow.
Yes. And then you would have to enroll in and complete the 6-month drug program, which will require you to go to meetings. That's individual
Okay,
meetings and
That's
group.
fine. I already have something in mind.
Okay. So that's what the option you want to do, correct?
Yes, get released today and then go to DEA office tomorrow and do the swab test and all that.
All right. Well, you have the right to have not guilty plea entered today and have a jury trial start within 30 days of today. By going with the OTP program, I'm going to continue your arraignment to October 2nd. Where will that be, Madam Clerk?
C-54.
That'll be in Department C-54 of the Santa Ana Court. That'll be on October 2nd, but I can only do that with your permission. Do you give me permission to continue your arraignment to October 2nd?
So, but I'll get released tonight if I go there October 2nd,
You'll have to come back to court on October 2nd, yes.
but I'll get released tonight.
Ma'am, I've already told you about 5 times you'll be released tonight. I'm happy to tell you
Okay.
for a 6th time.
You got to tell her again.
Perfect, that sounds perfect. I've been to the court before, so I'm definitely gonna go there tomorrow.
Okay,
If I
but
really need to, but October 2nd, I'll definitely gonna be there.
okay, but you have to listen to me carefully, okay?
Yes, sir.
Do you understand that you have a right to be arraigned today and have a jury trial conducted within 30 days of today, yes or no?
Yes, sir.
And by continuing this arraignment to October 2nd, you're going to waive that speedy trial right. Is that acceptable to you?
Yes, sir.
Okay, that'll be the order of the court to continue the arraignment to October 2nd, 2025 in Department C-54 with the applicable time waiver. That'll be
So
to...
I have to have my,
Let me finish. Let me
6-month
finish.
program and my, the swap, right?
Yes, ma'am.
Okay, I will definitely have that, by October 2nd.
That time waiver will apply to all 3 cases. That continued arraignment date, October 2nd, 2025, will be on all 3 cases. Ma'am, you're ordered to go to the district attorney's office tomorrow to fill out the paperwork, give your DNA
I really thought that one he was going to stand his ground and make her be quiet. And he just didn't. He just let her talk.
sample, listen to what the district attorney's office tells you that you need to do. If you successfully complete the program, all of these cases will be dismissed at the end of the program. So good luck to you, okay, ma'am?
So it's C-54, right?
Yes, ma'am, it'll be on your paperwork, okay?
Okay, awesome. Thank you so much.
You're welcome, ma'am.
I'll see you tomorrow.
Well, the DA's office tomorrow.
DA office tomorrow. Thank you very much.
You're welcome, ma'am. Good luck to you.
There, Judge, she's coming to your house. She's going to thank you with cookies.
Thank you.
There you go. 29. Calvin Tran Lee.
Yes, sir.
Welcome to court, Mr. Lee.
Oh, it's nice to see you.
Good to see you.
Thank you, sir.
Is your date of birth November 6, 1982, sir?
I hope that that day, I think so.
That's your birthday?
I think so. Yeah, it is.
Okay. Well, sir, let me go over the charges with you so you understand why you're here, okay?
Yes, sir.
I don't know if it's true or not, but these are the charges, okay? It is alleged on August 15, 2025, you violated a protective order, having suffered a prior protective order violation. That's why this has been charged as a felony. There are factors in aggravation alleged, along with a strike prior from 2018. The public defender is appointed.
Thank you, Your Honor. Marie Simmons for Deputy Public Defender on his behalf. I acknowledge receipt of the complaint. Waive formal reading and advisement, enter pleas of not guilty, reserving all motions, state constitutional rights. Requesting all discovery, and I'm asking to re-release him on PARS. I spoke to my client. It sounds like there was a misunderstanding in the sense that he thought the restraining order had expired, as it was served on February 22nd of 2023.
What really happened to
Based upon that, I'm requesting to have him be re-released on parks. He does have another place to go to. I talked to him about how he cannot go to his parents' house. He understands that now, and I'll submit on that.
People?
All right, people would be requesting scheduled bail as well as a no contact protective order in this case.
All right, before we get to that, let's set a pretrial August 26, preliminary hearing August 28. Those are statutory dates. Both those will be held in C-55 of the Santa Ana Court. Ms. Dinsmore, any objection to me looking at your client's rap sheet?
No.
All right, the court is looking at Mr. Lee's 24-page rap sheet. I'm looking for crimes of violence, and I am looking for warrants. 2018, there is a 368 felony conviction along with a 245A1. Give me 1 second to look this over. In 2021, there's a battery on a custodial officer. That's a felony. 2 counts of that. That is a violent felony in the court's opinion. There's a violation of parole from 2022. That concerns the court because it does indicate an inability to follow directives. There's a felony evading from 2023, which makes Mr. Lee PARS ineligible, along with a violation of protective order from 2023.
Understood. He's ineligible for PARS. I just asked for nominal bail as he doesn't have a job and don't believe he has a place to stay.
Looks like there's a second felony evading from 2024. Another violation of parole from 2025, which again concerns the court because it shows an inability to follow directions or directives. There's an arrest for violation of a protective order from 2025. That is actually this case. The court determines, based on the evidence presented, the criminal history of the defendant and the nature of the charged offenses, that public or victim safety cannot reasonably be assured without the setting of bail, and that by clear and convincing evidence, no non-financial or less restrictive conditions of pretrial release will achieve these goals. Court will set bail in the amount of $30,000. Ms. Dinsmore, you want a bail review August 26th?
Yes, please.
Bail review will be granted for August 26th. Dates will be pretrial August 26th, preliminary hearing August 28th. Both those will be in C-55. That'll be the order of the court. Anything else for the people? Anything else for the people?
Yes, sir. People were requesting a no contact protective order in this case.
If you give me it, I'll sign it.
Thank you.
No, this is ridiculous. I told you the story, I didn't believe that. You told me that's what you said. And you said when I asked you, you said,
What's that?
you said you couldn't
Yeah, I will tell you as soon as I get it. Deputy Hamilton, can you keep him here so I can go over the protective order with him?
You wasn't tripping. Why would you say?
We're still streaming.
He's done.
Okay.
Ms. Dinsmore, did you go over this with him?
I'm sorry, what?
Did you go over this protective order with him?
I did not, I don't, yeah, I know, I didn't have any.
Because we're live streaming, I don't really want to say the name of the protected person.
I mean, I told him
he knows who it is.
Okay.
And so I did a thorough conversation, right? So.
Okay.
I mean, whether it applies or not.
We're about to find out.
Know this. What? Yeah.
Oops, that would be
Let's
my
go back
fault.
on the record
There we
in
go.
connection with case 25 CF 3337. Mr. Lee, I'm going to read to you a protective order. Your attorney has told you who the protected parties are, correct?
Yeah, it's expiring in November.
Okay, sir, you are to not attempt to or actually prevent or dissuade any victim or witness from attending a hearing, testifying, or making a report to any law enforcement agency or person. You must not harass, strike, threaten, assault, sexually or otherwise,
No, I'm not a
hit,
guy.
follow, stalk, molest, destroy, or damage personal or real property, disturb the peace of, keep under surveillance, annoy by phone or other electronic means, including repeatedly contacting. You're not to impersonate on the internet electronically or otherwise, or block the movements of the protected persons. You must not contact the protected persons directly or indirectly by any means, including by telephone, mail, email, or other electronic means, or through a third party. Contact through an attorney under reasonable restrictions set by the court does not violate this order. You must stay 100 yards away from the protected persons and their home, job, or workplace, vehicle. Do you understand the protective order?
I guess.
Yes or no?
Yes.
All right.
It is, yes.
That'll be the order of the court. Thank you so much. Good luck, Mr. Lee.
Well, but
Court is adjourned.
stints will make it feel better, won't it? The blood will flow better. Okay.
The
Now,
Superior Court for
now we're going to the lawyerly part, guys. This is court, where they say lots of law stuff. No breakdowns, no crying. I promise, Judge, I'll show up. I promise. Just let me go. Can I go home today? But this judge is stern is a word. It's not the word I'm looking for, but not annoyed, not grumpy. It's gonna stick with stern, so he's fun to watch.
the Hartford Judicial District is now open and in session. The Honorable James T. Graham presiding. Good morning, Your Honor.
Good morning, everyone. Just a reminder, this is short calendar number 3, the special proceedings calendar. We are on the record. The clerk is
Connecticut. I can't remember which county in Connecticut. I'm sure it's there at the top, but I can't read that. It's way too tiny.
sitting in a hearing room open to the public. And we are also simultaneously live streaming on the Judicial Branch YouTube channel to allow public access. The first two matters I am going to call together because they have been consolidated by court order. Ambia versus Bangladeshi American Association of Connecticut and Rahman versus Bangladeshi American Association of Connecticut. For the record, who was present on that matter, please?
Good morning, Judge. My name is Anamo Ambi. I'm present.
Thank you.
Good morning, sir. This is Moinul Rahman. I'm present.
Thank you. Do I have defense counsel?
Yes, Your Honor. Good morning, Andrew Cohen for the defendants.
Very well.
Do I have any interpreter, boss? Do I have any interpreter? Because last time
You did, and the clerk noted that, I assume, and requested an interpreter. Do we have an interpreter, Mr. Clerk?
Your Honor, as of this morning, we got confirmation that the interpreter was ready to provide services remotely today, although I do not see them in this call. Prior to the start of this hour's docket, sent them another message, but have yet to get a response.
All right, we will pass this matter and we will come back to it. And I have two clerks today. Would one of them please reach out, perhaps by telephone, to the interpreter's office and tell them we need them now for a 10 o'clock hearing? Thank you. Performance Lab versus Tepper. Performance Lab versus Tepper.
Good morning, Your Honor. Ronald Pugliese representing the Performance Lab, and I have my client Rebecca Lavaway here with me in the office.
She's welcome, of course. And defense counsel filed an appearance 3 days ago.
Yes. Good morning, Your Honor. Nicole Millet with Littler Mendelson for the defendant.
All right. Well, let me ask the obvious questions. Have there been any settlement discussions?
Yes, there have, Your Honor. We made a demand late last week, and the defense has acknowledged that demand, and obviously takes them a little bit of time to go through it and speak with their client over it. So we're not, we don't feel rushed, but we have made a demand, and we're just waiting on a response.
Your Honor, we're preparing our response now. We anticipate having it early next week.
All right. Is this going to be a response as in go pound sand, or is it going to be a financial response so that you can have some meaningful settlement negotiations?
It will be a meaningful response, Your Honor. It will not be to go pound sand.
Thank you. All right. With that in mind, is it acceptable to both parties for me to continue this status conference to a subsequent date and allow you a chance to report back on your negotiations? These type of cases generally, not always, but generally resolved after settlement negotiations.
I think that's okay with us, Your Honor, but I'd like to keep that time sort of as short as possible before at least scheduling the hearing, and you can always ask for a continuance or cancel it if we've come to a resolution or are in meaningful talks. But I think we'd be more comfortable at least having a set time for this.
4,000 for this, 850 for this. Okay? And here's a number if you want to call. So this is mine.
All right. Whoever is calling in, you're calling in the middle of a court hearing with multiple parties, and I really don't need to hear you talking, sir. Are you by any chance the interpreter, the Bangladeshi interpreter?
Hello?
Hello?
Hi, good morning.
Are you the Bangladeshi interpreter?
No.
All right, well then, why don't you hang on, wait until I call your case, and then I'd be happy to hear from you, because right now I'm calling 4 or 5 cases. So just a moment, hang on, please. And if you could cover your speaker part of your phone in the meantime, that will prevent any background noise from being recorded. Thank you. I'm sorry, Attorney Pugliese, you were basically saying you want this all done sooner rather than later, which is...
Some people just don't know how to use their mute button. Unlike me, they can't figure it out. It's not that hard, people.
The normal plaintiff's counsel response and request. Mr. Clerk, what's the first what's the first reasonable date that we can bring this back on the status calendar?
Your Honor, we have October 9th at 10 o'clock a.m. Is our first reasonable date.
Is everybody available? I'm not hearing anybody's not available. October 9th at 10 a.m.
I just
wanted to be available, Your Honor.
Your Honor, yes, I'm available.
Thank you very much. I know it takes a moment to check. October 9th at 10 a.m. And I'm sure you'll have fruitful negotiations in the meantime. Thank you very much.
Thank you, Your
Honor.
Thank you. Casey co-executor versus Baker and Kelly. Do I have appearances on that file?
I'm sorry, Your Honor. That's an 11 o'clock case on my docket.
Yep, you're absolutely correct. Thank you. Town of Windsor.
Chat would be so much better if y'all had a mute and unmute when you wanted to chat something. Because then you would all understand. It's a pain in the ass.
Versus Carr.
Your Honor, may the clerk report back regarding the interpreter?
Yes.
Yeah, I spoke with our interpreter's office and we do have an interpreter for these matters. He is currently engaged on a case in Middletown, but he will become available for this block as soon as possible.
Any idea? As soon as possible, noon, 11 o'clock?
Should be available for this block, Your Honor, for this 10 a.m. block.
Well, the 10 a.m. block's going to end in about 3 minutes or 4 minutes.
Yes, Your Honor.
I mean, I've only got one other case plus those 2 cases. So, it's nice when people can double book, I guess, but it doesn't quite work for the court. So what we're going to do is we're going to call now Town of Windsor versus
Judge, sir, I know that your court is very important to you, and you think that it should be very important to everybody else. But how many of these interpreters do you think are hanging around Connecticut right now? I mean, you should be happy that this person is on his way over or her way over to you.
Carr, and hopefully our interpreter will make himself or herself available soon. It's now 10:08 a.m. All right.
10:08.
Attorney Deneen, and
that means the docket started 8 minutes ago, which I'm sure means in Middletown. I don't know if they say Middleton or Middletown in Connecticut. I don't know. So I tripped over my words there. But which means that docket started 8 minutes ago. Give the person a chance, Judge. Relax.
Attorney McNeil, I see you here on Windsor versus Carr.
Good morning, Your Honor. As you may recall, we had filed a motion to amend and add what we believe to be the operator of this activity. We've done that. He was served. I filed the return this morning. I think that probably I'll let Attorney McNeil weigh in. I'll file some defaults, and if we can get judgment and hopefully an execution to get them out of there, that might solve everybody's problem without the debate of Attorney McNeil's client's responsibility. I think that's probably the cleanest way to try to get this through.
So you're asking for me to mark this over?
I think so. I think that, and Tom and I can talk, Attorney McNeil and I can talk, but I think that's probably the cleanest way to get these people out of there operating this business in an improper location. So.
All right, and for the record, let me inquire, is there anybody present from City Line Detailing and Tints LLC?
May I speak, please, Your Honor?
Yes, ma'am.
Okay, I'm sorry. This is Elfreda. I just couldn't get on the video, but I'm here on the phone.
And I'm sorry, could I have your name again, please?
Elfreda is my first name. My last name is Carr. I am the defendant.
I'm representing. Yes, and Attorney McNeil is here to speak for you.
Okay.
You hired him, right?
Yes, he's not there today, or is
he? He is here. He is here to
Okay,
speak for you, ma'am. So you're welcome to listen, but an attorney is representing you, so I'm going to ask you to let him do his job, please.
In other words,
thank you, Mrs. Carr. What I was looking for was whether someone is here on behalf of Antoine Walters or City Line Detailing and Tints LLC. No response. Attorney McNeil, what would you like to say, sir?
Yeah, I think it'd be appropriate to mark it over because my understanding is that Anton Walker is no longer occupying that fourth bay. And I think he still has some items in there, but he's essentially been evicted, and there's a few things to still be removed, but he's no longer, with my understanding, is he's no longer operating from that location.
That person could be JK. That could be JK. We don't know. I mean, it's just someone online that we see. There's letters. That person, that would be hilarious. Wouldn't that be so funny if they wouldn't admit it. If someone from my chat showed up in one of these court hearings, they wouldn't admit it, but that would be cool if they did. That's me, guys. Just a little bit. No one's getting yelled at in court vibes, though. I thought that lady was gonna get in big trouble. He did slap her down a little bit.
Is anybody collecting rent from City Line Detailing and Tints LLC? And if so, who?
Well, I think the owner of 230 owns that Fourth Bay, which was the Anton Walters was the occupant of. But I think the owner of 230 Windsor evicted Antoine Walker from that Fourth Bay.
Yeah, JK.
And who is the owner?
You're right. But we don't have proof that you're from New Zealand. We don't have proof. You could be from Connecticut and just lying to us. And that could have been you on that phone right there, talking in court. In front of, like you don't know how to act in court. You know how to act in court. There was no reason for you to talk like that up there in Connecticut. I love when I'm in Pennsylvania and I can say up there to other people. Yep. Anybody else live in New Zealand that's seen JK in real life over there? Anybody? See JK? Nobody's sticking up for you, saying I saw JK in New Zealand today. So you could be. You did. You and not only did you know what slice was, you said it in a way. So Nan asked, was it pie or cake? And you were like, it's slice. So you just repeated the word back, expecting everybody to know what slice is, and only someone who lives in a place where slice is just a normal word would say it like that, and that's definitely not Connecticut. I'm in Pennsylvania, so I'm close enough to Connecticut to know that no one there knows what slice is. Not one person. Okay, maybe one person, but we would have no idea. Now we all know, and now we're all hungry. Darn it, why couldn't you say I knew what drop bear was or something? I don't know. What else is New Zealand?
Owner of 230 Windsor. Is it City Line Detailing?
It is not, Your Honor.
No idea.
Well, I don't have the owner of that other property as a party then.
No, it's not.
Who is the owner of that other?
It's not a slice of pie or cake. That's the name of the dessert. Slice. You can make it in a couple different ways, and CJ put some pictures. Oh, pizza. Oh my gosh. I'm gonna spend my whole first paycheck on breakfast in a second.
Property.
Craig Francis.
I'm sorry, ma'am?
The owner of 230 Windsor Avenue is Craig Francis.
Craig Francis.
Yes, he owns the whole apartment building, and we share the parking lot.
Okay, well, he's not a proposed defendant in this case. Only the tenants, apparently.
Yeah.
So I just point that out, Attorney Deneen.
Yes, this it's an odd configuration of these properties, Your Honor. There's a building that straddles the property line and various easements, but from the zoning enforcement officer's view and from our review, and Attorney McNeil and I've had some conversations on this, we believe the activity is occurring on the property that Ms. Carr and the defendant is located on. But whether we obtain a default and judgment, or if it's Attorney McNeil, they're in the process of getting them cleared out, this may resolve itself sooner rather than later under either of those circumstances.
How long do you want me to mark it over for?
Whatever the
October 9th, unless you're coming back on another case. I have a recollection you are.
October 9th will work fine.
October 9th.
Hopefully.
It works for me too, you know.
Thank you. It's 10 a.m. work for both.
Gosh, Lice Rage, how are you? I haven't seen you in a year. It was so good to see you again, and you're restarting, so you won't hear this. But you know, that's life. That's the way life hate works.
Both you gentlemen.
Yep. Thank you, Your Honor.
Thank you. October 9th at 10 a.m. I look forward to hearing from you then. Let us return, because we have the interpreter now, to the two consolidated cases, Ambia versus Bangladeshi American Association and Rahman versus Bangladeshi American Association. Good morning, Madam Interpreter.
Good morning, Your Honor.
All right, let me proceed, and I will, everybody needs to remember to pause occasionally to allow the interpreter to interpret.
নমস্কার, আজকে শুরু করা হচ্ছে যেখানে দুটো কেস একসঙ্গে, রহমান আর আমরিয়ার বাংলাদেশি অ্যাসোসিয়েশন আমেরিকান অ্যাসোসিয়েশন অফ কানেক্টিকাটকে নিয়ে। মনে রাখবেন যে এখানে দোভাষী থাকার কারণে মাঝে মাঝে একটু থামবেন যাতে দোভাষী সেটাকে অন্য ভাষায় ট্রান্সলেট করতে পারে।
Earlier this month, the defendant filed a motion to dismiss.
আমরা আজ এই মাসের প্রথম দিকে এখানকার যে বাদী আছে তিনি মোশন করেছিলেন যাতে কেসটাকে শেষ করে দেওয়ার জন্য।
And it claims a lack of subject matter jurisdiction.
এখানে বলা হয়েছিল যেখানে যতটা তথ্য দরকার ছিল এখানে যেখানে jurisdictionের দরকার আছে সেটা ছিল না।
The same motion was filed in each of these two cases.
Wow, thank
একই
you.
মোশন দুটো কেসেই করা হয়েছিল।
Multiple level. Thank you so much.
The case law is clear. When there is a motion to dismiss challenging subject matter jurisdiction, the court should do nothing before that is decided.
এখানে যেখানে কেস লগে বলা হয়েছে যে কোর্টের দ্বারা কোনো কিছুই করা হবে না যেখানে তথ্যর ব্যাপার নিয়ে কথা বলা হয়।
My hands are tied with regard to any other motions or aspect of these cases.
এই কেসের আর কোনো ব্যাপার নিয়ে
And that's why civil cases like this take years and years and years and years. Some types of motions, when you put them forward, stops everything until you try just that one piece. And of course you need witnesses and you need evidence for your motions hearings, and that's why it takes years and years and years. And I wish Pegleg was here. No, this is all lawyers. We don't have anybody crazy acting crazy right now, just straight lawyers doing lawyer things, saying lawyer words.
আমরা কিছু কাজ করতে পারবো না, আমাদের হাত এখানে বাঁধা আছে।
Until the motions to dismiss are decided, I can do nothing with regard to these cases.
এই কেসের ব্যাপারে আমি এখন কিছুই করতে পারবো না যতক্ষণ না এই মোশনটা যেটা খারিজ করার মোশন করা হয়েছে সেই মোশনটা নিয়ে কথা বলা হোক।
As of now, the motions to dismiss are calendared for October 6th.
এখন পর্যন্ত এই মোশনের জন্য যেটা খারিজ করার মোশন করা হয়েছিল সেটার জন্য অক্টোবর 6 তারিখের তারিখ ঠিক করা হয়েছে।
I do not know which judge will hear the motions that day or subsequent that week.
আমি ঠিক জানি না কোন জাজ মশাই সেই দিনকে পরিস্থিতিতে শুনবেন, শুনানিটা করবেন, বা সেই সপ্তাহে আর কোনো শুনানি যদি হয় কোন জাজ সেই শুনানিতে থাকবেন।
The defendants need to file their objections or responses to the motions to dismiss in the near future.
এখানে আগামী কিছুদিনের মধ্যে বা কিছু সময়ের মধ্যে যারা প্রতিবাদীরা আছেন তারা এই মোশনের ব্যাপারে যদি আপত্তি জানাতে চান বা কোনো কিছু আপত্তি রাখতে চান সেটা ফাইল করে দেওয়া হয়।
The plaintiff's attorney is directed to mark the motions to dismiss ready when they appear on the calendar.
আর যারা উকিল আছেন, বাদীদের উকিলরা, তারা যেন নিজেদের ক্যালেন্ডারে খেয়াল রাখে যে ক্যালেন্ডারটা রেডি হয়ে যাবে তারা যেন মোশনটা তৈরি করে রাখে।
The motions will likely be heard remotely on October 6th, but they may be scheduled for a subsequent date later that week, depending on the judge's schedule.
জাজের স্কেডিউল অনুযায়ী হয়তো সেই দিনকে অক্টোবর 6 তারিখে এটা রিমোটলি শোনা হবে এই শুনানিটা, আর আগামী যা শুনানি সেই সপ্তাহে হবে সেইগুলো হয়তো সেদিনকেই জানানো হবে।
Is that better with my microphone?
I do not know which judge will hear them. It is probably not me.
আমি ঠিক জানি না কোন জাজ মশাই সেদিনকে উপস্থিত থাকবেন। আমি যতদূর জানি আমি সেটা নই।
Judge, can I speak?
Yes.
So I did put in a motion for objection for that already.
Right. That's nice, but it doesn't give you an earlier hearing.
Okay. No, this is my first time, Judge. I'm just trying to figure it out.
That's okay, Madam Interpreter.
আমি এখানে প্রতিবাদী বললেন যে আমি অলরেডি ওই মোশনটা জমা দিয়ে দিয়েছি। তো উনি বললেন যে হ্যাঁ ঠিক আছে, তার মানে এটা নয় যে তারিখটা আগিয়ে দেওয়া হবে। বললেন না, আমি এটা প্রথমবার করা হচ্ছে সেই জন্য আমি জানিয়ে দিলাম। তো বলে ঠিক আছে।
So, Mr. Rahman, you must file your written objections to the motion, if you have them, before the hearing, well before the hearing.
এই যে শুনানির তারিখের বেশ কিছুদিন আগে আপনি জানেন মিস্টার রহমান,
Thank you, Kelly. Thank you.
আপনার যে আপত্তিগুলো আছে সেগুলো ফাইল করে দেবেন।
You have, by my recollection, 30 days from the date the motion to dismiss was filed, which was August 21st.
অগস্ট 21 তারিখে এই মোশনটা ফাইল করা ছিল খারিজ করার জন্য। তারপর থেকে 30 দিন আমার যতদূর জানি আপনার সময় আছে এই মোশনটা আপত্তিটা ফাইল করার জন্য।
Are there any questions, or do any of the parties or counsel wish to comment further?
এখান থেকে কোনো প্রশ্ন আছে কি? আপনাদের কারোর কাছ থেকে কোনো প্রশ্ন আছে কিনা? আর যদি কিছু পার্টির কেউ কিছু বলতে চান।
Attorney Cohen.
Thank you. I have a couple of scheduling kind of questions for you. One is that it appears that for short calendar on September 8th, that all three matters showed up, according to what I saw, including the defendant's objections to the motion to dismiss. So that showed up in my notices, and their own two motions.
On which calendar?
Well, on the website, I can check short calendars for my juris number, so I checked on that, and it showed on September 8th on the civil calendar, and I'm not sure which number. All three of those.
That makes a big difference. So we're going to pause now and let the interpreter translate.
আপনি এখানে জাজ সাহেব যখন বললেন যে অ্যাটর্নি কলিনকে বলতে জন্য উনি বললেন যে আমি যখন চেক করেছিলাম যে শর্ট ক্যালেন্ডারটা বলে বা তাড়াতাড়ি দেখানো ক্যালেন্ডারে সেপ্টেম্বর 8 তারিখে সিলেবল ক্যালেন্ডারে যে আমাদের ওয়েবসাইট আছে তাতে দেখাচ্ছিল যে এই অবজেকশনের ডিসমিস করার জন্য অবজেকশনটার জন্য অলরেডি ওখানে ফাইল ছিল যেটা তিনটে ব্যাপার নিয়ে রাখা ছিল তিনটে ম্যাটার ছিল সেটা জাজ সাহেব বললেন যে ওটা কোন ক্যালেন্ডারে আপনি দেখেছেন উনি বললেন যে আমি আমাদের যে উকিলের ক্যালেন্ডার হয় সেই থেকে দেখেছিলাম তো জাজ সাহেব বললেন হ্যাঁ তাহলে তো অনেক জিনিস বলতে চাইছি
Calendar 10
Wow,
is the
Lisi.
non-arguable matters.
Look at Lisi coming in. Lisi, 15 months. 15 months. Thank you so much. I appreciate it.
Does not include matters of law, and the objections may have printed on that calendar.
যেটা ক্যালেন্ডার 10 নম্বর বলা হয় সেটা হচ্ছে যেখানে কোনো তর্ক বিতর্ক হয় না যেই শুনানিতে কোনো তর্ক বিতর্ক নেই আর যেটা আমাদের নিয়ম বা ল এর সাথে চলে না হতে পারে সেই ক্যালেন্ডারে কোনো সময় ওটা প্রিন্ট হয়েছে
But I am directing all the parties and counsel to not mark any matter ready before the motion to dismiss is marked ready and heard.
আমি এটা সব পার্টিকে আর তাদের উকিলদের বলে দিচ্ছি যেন কোনো জিনিসকে রেডি কোনো ক্যালেন্ডারে রেডি না রাখে যতক্ষণ না ইমোশনটা যেটা ডিনাই করা যে বা ছাড়ার মোশনটাকে করা হয়েছে সেটা যতক্ষণ না শুনানিতে আসা হয়
And that's calendared for October 6th.
এটা হচ্ছে অক্টোবর 6 তারিখের ক্যালেন্ডার
And by law, that's the first matter that must be heard.
নিয়ম অনুযায়ী সেটাই প্রথম ব্যাপার শুনানিটা শোনানো হবে
Thank
So,
you, Your Honor.
You're welcome.
ধন্যবাদ
I am marking these two cases temporarily off of the special proceedings calendar.
আমি এই দুটো কেসকে যে স্পেশাল প্রসিডিং ক্যালেন্ডার আছে তার থেকে বার করে দিচ্ছি এখন
If and when the motion to dismiss is denied,
যদি কখনো এই যে মোশনটা করা হয়েছে খারিজ করার ওটা যদি বাদ দিয়ে দেওয়া হয়
then the plaintiffs should contact the clerk for this docket to have this matter placed back on the docket.
তাহলে বাদীরা এই ব্যাপারটাকে দেখে নিয়ে পর আবার ডকেটে যাতে দেয়া হয় সেটা নিয়ে কোর্টের যেন জানায়
Your Honor, if I may, I also have a question about the week of October 6th and including the issue about remote versus live proceedings. And I understand you don't know which judge may preside.
আমার একটা প্রশ্ন আছে যদি আমি পারি যে 6 তারিখে সপ্তাহের যে শুনানিগুলো হবে সেটা নিয়ে আর এটা রিমোটে হবে
No, sir, but if you tell him which judge you prefer, maybe he can work something. Maybe he can work something out.
এটা নিয়ে আর যে আপনিও এটা জানেন না যে কোন জাজ মশাই সেখানে থাকবেন
My only concern, Your Honor, is I am going to be in Washington, D.C. the entire work week, and I certainly could attend a remote argument. I am concerned if the argument were scheduled live, it would be very, very difficult for me to attend.
You mean in person?
Thank you. Yes.
আমার একটি শুধু প্রশ্ন ছিল যে তো আমি সেই সব পুরো সপ্তাহটা ডিসিতে থাকবো সেই জন্য আমি যদি রিমোটলি করা হয় আমি নিশ্চয়ই আর্গুমেন্ট গুলো দিতে পারবো কিন্তু যদি আমাকে শারীরিকভাবে ওখানে থাকতে হয় তাহলে একটু অসুবিধা হবে
I suggest that you file a case law request as you get closer to that date. That will be presented to the presiding judge. She will make the determination whether to order it to be held remotely. That's my suggestion.
আমি একটা জিনিস বলতে পারি আপনি কেস ফ্লোটা দিয়ে দেবেন দিয়ে জানাই দেবেন ওই সময় জাজকে বেশ আগে থেকে জানিয়ে দেবেন যাতে কি আপনি বলতে পারেন যে আপনি থাকবেন না সরাসরিতে থাকবেন না তাহলে উনি দেখে সেটা রিমোটলি করার চেষ্টা করবেন
Thank you, Your Honor.
Anybody, either of the plaintiffs have any questions at this point?
বাদীদের কেউ আছে যাদের কোনো প্রশ্ন আছে কিনা?
So, Judge,
He's
they're asking to dismiss.
he's traveling and moving Mississippi. So he's painting his garage or something. I don't know exactly what he's doing, but he's getting ready. Next spring, I think he said, to move. Looking for property right now, trying to get his house ready, I think, for sale. So yeah, he's been busy doing real life things.
Miss the election itself.
No,
But
they're
the-
actually
the-
to dismiss your case.
The full case, even though there's some parts that, I have requested documents from them from day one, and I still haven't gotten any.
Madam Interpreter.
কেসটাতে যেখানে আছে যে ওরা কি চাইছে যে পুরো কেসটা বা ইলেকশনটা শুধু বাদ দিতে?
Were you not paying attention? The judge cannot do anything at all with this case because they filed those other motions. Until those other motions are heard in some way, shape, or form, nothing else matters. It doesn't matter. You're stuck, and you're going to stay stuck for years, I bet.
জাজ মশাই বললেন যে না, ওনারা চাইছেন যে আপনাদের করা কেসটাকে খারিজ করে দেওয়ার জন্য। এখানে কেসটা উনি বললেন যে কেসটা কেসে কিছু অংশ আছে যেখানে আমি কিছু ডকুমেন্ট চেয়েছি প্রথম থেকে, সেই ডকুমেন্ট গুলো এখনো পাইনি আমি।
They are seeking to dismiss the entire case. That's correct. If you believe it's improper at this point, that should be part of your argument, Mr. Ambia. But
Ambia.
Go ahead, Madam Interpreter.
মিস্টার আম্বিয়া, আসলে ওরা পুরো কেসটাই খারিজ করে দিতে চাইছে। আপনি যদি মনে করেন এটা ভুল হচ্ছে, যে আপনি তখন এইগুলো আপনার নিজের আর্গুমেন্টের মধ্যে দিতে পারেন।
Mr. Rahman, do you have any questions, sir?
মিস্টার রহমান, আপনার কোনো প্রশ্ন আছে?
No, sir, thank you. আমি শুধু একটা বিষয় জানতে চাই, ওই যে মার্ক মেটার রেডি ক্যালেন্ডারটা, ওইটা
Eileen, it was probably because I was a mod in Fleischer's courtroom back then when it first started.
মানে কি, ওইটা কোথায়?
So, not at this moment, but yes, only one question I have. You mentioned something about the marking ready. What is that, and where would I see that?
The calendar, Mark Metal calendar.
Mark the ready calendar.
Yep, marking ready is what you must do when a motion appears on a calendar. I have directed plaintiff's counsel to mark the motion to dismiss ready. I have directed both you, Mr. Rahman, and Mr. Ambia to not mark anything else ready before the motion to dismiss is ruled upon. Marking ready means it'll be presented to a judge for a ruling.
আমি এখানে বলেছিলাম মার্কিং রেডি মানে হচ্ছে যখন ক্যালেন্ডারটা শুরু হবে। তো প্রথমে আমি বাদীতে বলেছি যেন ডিসমিস করা, যেটা করা হচ্ছে খারিজ করার কেসটা, সেটা যখন মার্ক রেডি করতে, যাতে ওটা প্রথম শুনানিতে শোনানো হয়। ওই শুনানির ওপরে যেই তার নিয়ম বেরোবে বা জাজমেন্ট দেবে, তার ওপরে ডিসাইড করে তারপরে আপনাদের যারা প্রতিবাদী আছেন, আম্বিয়া আর রহমান, তারা নিজেদের কেসটাকে রেডি করবেন। তার মানে রেডি করা মানে হচ্ছে যে সেটা জাজের কোর্টে আসবে শুনানিটা তো শোনার জন্য।
What we're going to do now is I am going to recess until the 11 o'clock docket. But I'm asking the clerk and the interpreter to stay online in case either Mr. Ambia or Mr. Rahman, who are representing themselves, have any questions for the clerk about how motions are handled or marked.
এই সময় আমি জানাচ্ছি, আমি জাজ হিসেবে এখন আমি রিসেসে যাচ্ছি 11টার যে ডকেটটা আছে তার জন্য। কিন্তু আপনারা অনলাইন থাকতে পারেন, দোভাষীও এখানে অনলাইন আছে। ক্লার্কের সঙ্গে আপনারা কথা বলে জিজ্ঞেস করতে পারেন যে আপনাদের কিভাবে আগে গিয়ে ফাইল করতে হবে বা কোনো প্রশ্ন যদি থাকে।
And I'm going to ask,
That wouldn't have been me. I don't do Simpson, Boyd, or Middleton. I mean, I did Boyd recently because Josh wanted me to. Josh wants me to do Boyd. I'm gonna do Boyd. I don't know what it was. I wonder, Eileen, if I was in like Bill's American Courts. That was probably it. It was probably I was American Courts then, and you heard of me or saw me there, maybe, or you were just up at 4:30 a.m. like a normal person, and nothing else was on.
you, Madam Interpreter, to stay on to assist in that, but reminding everybody the interpreter has other commitments, so do not make it overly long.
Judge, you made
Thank you,
her
and we
stay.
stand in recess.
You got
জি,
mad at
অনার
her.
আমরা এখানে জানাচ্ছি যে দোভাষী এখানে থাকবেন, কিন্তু দোভাষী যেহেতু আর এর পরেও কিছু কাজ আছে, সেজন্য বেশিক্ষণ সময় দিতে পারবেন না। আপনারা যদি সংক্ষেপে তাড়াতাড়ি করে বলে দিতে পারেন, তাহলে কোর্টের আমি সাহায্য করতে পারি ক্লার্কের সঙ্গে।
Recess. We are simultaneously live.
And the Galicio defendants.
Good afternoon, Your Honor. Katie Roseman, Assistant Attorney General for Intervening Plaintiff, State of Connecticut.
And
Ben Ancona, Your Honor, for defendant number 6, Ava Properties.
And Michael Pedalano, Your Honor, at BBB Attorneys for Plaintiff Jennifer Nosal.
Is either LeVar Flanders or Ricky Beltran, who filed appearances on their own behalf, present? Record will reflect no response. Okay. What are we doing here, folks?
JK, you're right.
Your Honor,
They are.
plaintiff has filed a request for PJR. We
Yeah,
have
now I
been-
know that's why you're here.
Yes, Your Honor. I guess to streamline things, I'm not sure that there's been a pretrial. I know that we just had a hearing with regard to the pending motions for summary judgment. Those are actually due. My objections are due tomorrow, which I intend to file. If Your Honor would like to set it down for a pretrial first, I have no objection to that. If Your Honor would like to set it down for a PJR hearing instead, I am amendable to that as well.
Your Honor, John Miller for Bar on Cedar. I think the PJR is only directed to the Bar on Cedar. In speaking with my client's personal counsel, they would likely be open to, discussing some sort of potential agreement in terms of the security in lieu of the PJR. So I think that piece of it, we're open to talking about that. So I think it might be beneficial to allow some window to try to work something out with respect to that issue.
Yeah, the case is a year old. The PJR application's very recent. And I don't need to know why. I do need to know
I want to know
and
why.
confirm that the PJR sought only against the bar, in which case it would make sense to mark it over if, and I'm assuming, but I do want to confirm it, that there's an insurance coverage issue, either in terms of the amount or disclaimer. Plaintiff's counsel?
That is correct, Your Honor, and it is.
I don't understand what's going on right here. I tried to stick with it, but if there's a problem, they're bringing up something against the bar. That sounds like an attorney issue, but with an insurance premium, sounds like a civil issue. I don't know.
Currently the subject of a federal declaratory judgment action.
Yeah, that's correct, Your Honor.
All right, brought by the company, the insurance company, trying to disclaim coverage, set a fair statement.
That's correct, Your Honor. We received notice of that late June, I believe.
All right. I take it that you haven't had much in the way of the substantive discussions about the bar's willingness to provide security beyond the insurance coverage. That's a
No, Your
recent.
Honor, this is the first I'm hearing about it.
Yeah, no, we haven't, but that's something I spoke to the personal counsel who appeared.
Wait a second. It can't be. Nan, do you think when they say bar, they mean bar? Like a place to go and drink alcohol? And not the bar? As in, the lawyer has to pass a bar to become a lawyer? Because if they mean a bar, that would make a lot more sense. I heard the word bar the first time. I heard the word bar now, and it never even crossed my mind that they mean a place to drink alcohol. I don't know. I don't. Now I'm probably more confused than I was 1 minute ago.
In the DJ on Monday, and that's something we're both in support of. We'd have to speak to the client further, but we're both in.
And the DJ could mean disc jockey, or it could mean district judge. So that didn't help right there. That made it worse.
Support of that, and we think we're probably not going to get a whole lot of pushback.
Okay, and the bar on Cedar LLC, do they own the location they're operating out of?
No, they do not own the real property. In fact, I believe that's what Attorney Ancona is in for, is the real property owner.
All right. But as plaintiff's counsel, do you also agree that currently you're only seeking a PJR against the bar?
That is correct, Your Honor. That is all we filed against.
Okay, well, I'm running through my mind of the typical bar and what assets they have if they don't own the location where they're operating. So
it's a bar. It's a bar where you drink alcohol. Yeah. Why can't they just speak English? I guess why can't they say pub? Pub would have worked better in this whole context.
I don't know how much value shot glasses and the liquor on currently stored there, and the stools.
Yep, it's a bar. Fine, JK. You just said pub and slice. You are not from Connecticut. I'll give you that. I'll go that far.
Tables would have, but I'm going to give you time to discuss with each other some arrangements as to security, and I'm going to ask the clerk. You had an October 2nd at noon time slot, did you not?
Yes, Your Honor. We have
All right.
availability.
All counsel available then?
Yes, Your Honor.
Yes, Your Honor.
Disclaimers. I'm going to continue it to that date to allow discussions between counsel, including personal counsel for the bar, and plaintiff's counsel.
Thank you, Your Honor. And just to be clear, that'll be another status conference?
Yeah, it will be a status conference. Yes, sir. It's not
Thank you.
it's not an evidentiary hearing. It's a status conference. Thank you.
And Michael, can I speak to you after this? Can I give you a buzz?
Oh, yeah. You have my
Super.
number, right?
Yeah.
Perfect. Excellent.
Great.
All right. Thank
Thank you,
you.
Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, and have a good day.
Bye now.
All right. I believe the sole remaining matter, unless I missed a case on the noon docket, is J.G. Wentworth versus Kim Bradshaw as trustee. Am I correct, Madam Clerk?
You are correct, Your Honor.
J.G. Wentworth sues everybody, or everybody doesn't pay them like they're supposed to. I don't know. I'm trying to remember J.G. Wentworth. Don't they buy your annuities? So they give you a lump sum for annuities. So I don't know why people would have to pay them anything. I don't know, but I see their name all across all courts. Yeah, Cash Now, and they're constantly in court. They're like Citibank, or always in court. Yep, 877 Cash Now. Yes.
Okay. Then Attorney Hanson, Ms. Bradshaw.
Hello, Your Honor.
Let's proceed with that.
Please.
First of all, Ms. Bradshaw, do you want to raise your right hand?
Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Please state your name for the record, including the spelling of your last name, as well as the town in which you reside.
Kimberly Bradshaw, Bradshaw, in Weathersfield, Connecticut.
All right. First of all, I do
The jingle that you're hearing in your head, is it the opera singer one?
find notice to the insurance companies involved, Talcott Resolution, Sebsco, and Talcott Resolution Life Insurance Company, and Attorney Hanson.
Thank you, Your Honor. May I inquire?
You may.
Good afternoon, Mrs. Bradshaw.
Hi, Chris.
Ma'am, are you seeking permission from this court to transfer payments that you're entitled to receive from an annuity?
Yes, I am.
And specifically, these are payments that are due to the Josh Bradshaw Special Needs Trust. Is that correct?
It's correct. Yeah.
Of which you are the trustee?
Yes, I am.
Okay. Now, ma'am, you were presented a copy of the purchase agreement from my client, J.G. Wentworth Originations, LLC, regarding this transaction. Is that correct?
Correct.
Ma'am, from the moment you first received the purchase agreement until you signed it, did you have enough time to review it with either an attorney or financial planner?
Yes.
Did you in fact review it with either an attorney or financial planner?
No, I did not.
Okay. But you do admit and acknowledge that you had enough time to do so if you had so chosen?
Yes.
Okay. Ma'am, are you married?
Yes, I am.
And in addition to Joshua, do you have any other children?
No, I do not.
Okay. And how old is Josh?
It's John.
John, I'm sorry.
It's okay. He's 32.
32. Ma'am, are you currently gainfully employed?
No, I'm not.
Now you're seeking to transfer
I am. I have a job.
about
Yep.
16 years
Today's my
of
first
monthly
payday.
life contingent payments. Is that correct?
That is correct.
All right. The first 12 monthly life contingent payments are $269.35 each. And those are set to begin on July 5th, 2029 and on June 5th, 2030. Is that correct?
That's correct.
Ma'am, the last of the 16 years is 12 monthly life contingent payments of $8,826.17 each, beginning on July 5th, 2068, ending on July 5th, 2069. Is that correct?
That is correct.
Ma'am, do these payments represent the entire amount that you're to receive from the annuity, or is this only partial payment?
Partial payment.
And do you understand that if you did not enter into this transfer and instead waited to receive all of the annuity transfers, you would receive a total of $891,577.92?
Yes.
Do you further understand that the discounted present value of the aggregate purchased payments at the federal interest rate of 5% is $144,367.36?
Yes.
However, do you understand that if the court approves this transaction, you will receive $10,000?
That is correct.
All right, ma'am, obviously $10,000 is significantly less than you would receive if you had waited until 2069, correct?
Correct.
Can you please explain to the court why you believe entering into this transaction is in your best interest as trustee and why you need access to these funds in this manner?
Well, it's regarding John's health, and he's 32 years old. We are coming into where his body is starting to, it's starting to suffer. He has scoliosis severely, and we've been told that we have to do something about it, and we'd like to do it without surgery. So that requires swimming. It requires working with like a chiropractor, but more on using electrodes to, his muscles are very tight, so we have to loosen them up. And between that, and he does have Medicare, but I'm not sure what they'll pay. And we do not have Medicaid, but I am reapplying for it. And we need to do this, otherwise it's going to disable him even further. And
Ma'am, do you have the means to pay for this without entering into this transaction?
No.
Have you sought any alternatives, like a HELOC or a refinance of your house? Have you tried anything like that?
We rent, so I don't have that option. My husband retired, and I have stayed home with John since he's been 1 year old to take care of him.
Now, this is not the first such transaction that you've entered into, correct?
Correct.
Okay. And for what types of things have you used the money in the past?
Well, we've done therapeutic horseback riding. We've gotten a certain special bed for him. We have to maintain a car. Our car is 13 years old to take him to these appointments. We've had to get a wheelchair. So a lot of equipment that is very costly.
Now, are you asking this court to make a determination that this transaction is in your best interest and that the court approve this transaction?
Yes.
Your Honor, I have no further questions.
Ms. Bradshaw, this is an incredible discount, almost $900,000. Admittedly, in future years, some of them significantly off, but only for $10,000. You sure you want to do this?
Your Honor, I do, because it's his health and I don't want to see him suffer, and I have a way to help him if this is approved.
In making the decision to do this, are you factoring in the fact that these are life contingent payments?
Yes, Your Honor.
All right. Is it fair to say no one can say just how much longer John will live with his health problems?
Correct, Your Honor.
And you got the disclosure statement at least 3 days before signing the transfer agreement, correct?
Correct, Your Honor.
You talked with at least your husband before making the decision to do this, correct?
Absolutely, because we are his caregivers.
I understand. You're the trustee, though. Okay. All right. I have no further questions. Attorney Hanson.
Nothing further, Your Honor.
All right. I do find that, and just addressing counsel, I'm sure it was Talcott Resolution Life and Talcott Resolution Subsco or counsel for them that supplied you with the proposed order. Is that correct?
Yes, Your Honor.
All right. So I do find they have notice of these proceedings. I do find that the trust has only one beneficiary, and that being John Bradshaw. I do find it's in his best interest, based upon the testimony of his mother. I do find that the Connecticut statute requirements are met, and therefore I will sign and approve the order which I previously reviewed.
Thank you, Your Honor.
You are welcome, and the clerk will please come immediately after recess to pick that up in my chambers. I think we are done here. Thank you
Your
so
Honor.
much. Thank you.
Bye, Mr. Bradshaw.
Bye.
Right. Thank you. And we stand at this juncture, we stand until the 2 p.m. session in recess.
All right, guys, we made it to the end. Zach, thank you so much for the super chat yesterday. I'm sorry I wasn't here to receive it officially. I appreciate it. I do. Thank you. So, okay, so half of you were happy today with the crazy court videos. And I should say half. I should say 99% of you liked the first half of this live stream. And 1% of you were like me and thought this judge was pretty cool to watch, even though it was lawyerly, courty, wordy, not grasping it all, though. We got there in the end. I would love dearly to see someone misbehave in his court. I would really love to see him handle someone like that. I'm just tired of, it's always DUIs or domestic violence. DUIs or domestic violence. DUIs or domestic violence. That's like all court is anymore, you know? But so I try to throw different ones in, and sometimes they hit and sometimes they just really don't. But like, I thought the Texas A&M murder, and when the crane, not murder, you know, when the crane fell, I thought that was, you know, something we never get to see. That freaking lawyer, Anthony Buzz something. He's a big freaking deal. That lawyer that we saw during that Texas A&M case, I do too. I love custody cases. They get the most crazy out of all of them. Like yesterday, that never mind, that was different. So, I stopped uploading videos. Yeah, that was yesterday, right, Mom? The mom, contempt of court, and the mental evaluation. The lawyer starts and says, I want her to have a mental evaluation, I want her to have contempt of court. She doesn't even have the kids right now, and her defense was, when I had the kids, he didn't come and pick them up. What? He actually is, though. He can actually say, I'm kind of a big deal, and it means that he's kind of a big deal. Because he really was. He was such a pain, though. He was so annoying. Speaking of annoying, I'm about to start OJ. And we're actually getting the medical examiners on now, guys. So we started in December. It is September. And we finally heard, I think it was 2 days ago, we finally heard that somebody was stabbed. Lightly. I mean, we didn't hear a lot, but we actually heard that somebody was stabbed, and exactly how she was stabbed. It was not good. Well, now we have the medical examiner on the stand. So I'm thinking any day now, watching this murder trial that we put enough months in to have a baby, I'm thinking we might hear something about the murder today. I don't know. We'll see. I missed yesterday, so maybe he said something yesterday and I missed it. Probably. You know, they probably put every single detail of the actual murder in yesterday's whole video, because I was not able to see it. But I'm going to start OJ now. Guys, thank you so much for coming out. And remember, guys, I know I said it at the beginning, but there's more people here now, so I'm going to say it again. Yesterday I wasn't here at all. I put the court on and chat took over, because that's what Court Vibes is. Court Vibes is that chat. It's not court videos, You know, I try to find court videos that you'll actually watch, but I never ever succeed. Because nothing can beat our chat. It's so good, and our community and our friendships, and you know, there's no jerks involved. We're just all there to get through another day, because we know the rest of the day is going to suck, but at least for here we can forget about all of that and just hang out with our friends for a while. So I'm going to start OJ. Thank you for taking care of my stream yesterday. I appreciate it. I'll see you all again real soon. Bye, guys. Oh, we didn't have this. We didn't have this yesterday. I'm so sorry. I missed it.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide.